Name is Nashapat Piamtipanas. My article topic is about the Public Agency Right concerning Personal Data Protection Act or Thai PDPA. First, we're gonna look through the background of the case first. PDPA was newly enacted regulation, but before PDPA enact, Computer Crime Act was previously used to protect personal information. Because nowadays, social media become influence in our life. People make transactions online and use own identification information to verify oneself. So, it is necessary to protect those identification information to leaking to public or third person without owner's sought consent. Many of the principles and obligations within the PDPA were adapted from the EU General Data Protection Regulation or GDPR. Similar to the GDPR, the intention of the PDPA is to protect data owner in Thailand from the unauthorized or unlawful collection, use or disclosure and processing of their personal data. The PDPA also applies to organizations outside of Thailand that either offer products and services to individuals in Thailand or monitor that behavior of individuals in Thailand. The law is expected to have a significant effect on online service providers based outside of Thailand and inside Thailand that hope to continue to serve the Thai market. Thailand PDPA borrow a number of requirements from the GDPR. First, the law established a set of lawful-based organizations must use to possess data and owner information like the GDPR. This lawful base include consent, legal obligation, public interest, and legitimate interest. In addition, individual rights under the PDPA look very similar to those found under the GDPR, covering the right to access, object, erasure, and rectify. And finally, like the GDPR data protection authorities, the PDPA will establish a Personal Data Protection Committee or PDPC to enforce the law and publish guidance to help organizations to ensure compliance with the PDPA. Next, I'm gonna look through the scope of the PDPA. The PDPA covers personal data stored in electronic and non-electronic formats. It generally does not apply to any public agency in relation to the collection, use, or disclosure of personal data. So, the problem in this article is public agency has discretion to use, disclose personal information without consent. For example, Thaishana in Thailand that collect information without clarify what the information is used for which purpose. As stated in Section 4, Subsection 2 of Thai PDPA, this act shall not apply to the operation of public authorities having the duty to maintain state security, including financial security of the state or public safety, including the duty with respect to the prevention of suppression of money laundering, or cyber security. Next is the structure of the article. I'm gonna start with overview of Thailand of Personal Data Protection Act and how it changed society, how Thai people will adapt to the PDPA, and elaborate the right of data subject or personal data owner rights. For example, right to access the data, right to erasure. Next, I'm gonna demonstrate the problem of public agency having discretion to use or disclosure personal information without consent. Lastly, compare PDPA Thai with PDPA Singapore and EU GDPR. Last one, my progress on this article. I'm just research on the relevant law and case regarding use of information without consent of data subject and currently drafting the introduction of the article. Thank you.